My lords and my lady, the point to underscore in regard to those coalition agreements is that as early as the 8th of October 2024, when the first petitioner tendered his defense to the grounds that were purportedly moved by the National Assembly, it was clear that part of the evidence that the first petitioner was to present implicated or showed the involvement and the interest of the Speaker of the National Assembly. However, my lords and my lady, the Speaker of the National Assembly did not deem it fit to recuse himself, noting that the issue of his interest would play out in the defense of His Excellency Rigathi Gachagua. Further to this, when the motion was carried and a resolution was made by the National Assembly, the same material was presented to the Senate, and it could be seen, or reasonably believed that it was seen, by the then Speaker of the National Assembly, the Speaker of the Senate, that the coalition agreement that begot him his speakership was also in question, as it had been brought up by the first petitioner in his defense of ground one that had been then passed by the National Assembly. In summing up, my lords and my lady, impartiality is essential for decision making, and as my learned colleagues have indicated, the process demonstrated what my senior counsel, Mr. Ongwea, has referred to as malicious compliance, breakneck speed with regard to the moving of the motion, as well as the directions, as well as interpretation that was given to various provisions of the Constitution by both the Speaker of the National Assembly and that of the Senate. In summing up, my lord, the petitioner has, in his bundle of digest and bundle of authorities, made reference to the decision of Njiru and 11 others versus Kenya Kwanza Coalition and 18 others, which my learned colleague, Mr. Macharia, made reference to. I do urge your lordships and your ladyship, when this court retires to deliberate on the ruling, on the judgment, to be guided by the three judges in holding number 20 and 21 of that decision. I do submit that those two holdings are on all fours on the submission in relation to Article E before this court. Sorry, the issue for determination at E before the court. And in closing, my lord, with reference to the issue for determination whether or not the speakers of both the National Assembly and that of the Senate were neutral, I do invite this court to do what the court recommended in the decision of Philip K. Tunoi and another versus the Judicial Service Commission, and another, it's a 2016 decision, where the court held that in determining the existence or otherwise of bias, the test to be applied is that of a fair-minded and informed observer who will adopt a balanced approach and will neither be complacent nor be unduly sensitive or suspicious in determining whether or not there is a real possibility of bias. I do invite this court to apply that test. And my lords and your ladyship, based on what has been presented by the petitioner, we do submit and urge the court to find issue number E in the affirmative. I'm much obliged.
Thank you.